Good afternoon to everyone. My name is Murgo, and I'm a PhD candidate in labor law at the University of Pavia, Italy. And as you can see, today I'm going to talk about the possible connection between global unions and states in the regulation, in the social regulation of global supply chains. So, as you may know, global supply chains is a concept that encompasses the whole production and distribution activities carried out by different legal entities, but all led by one multinational corporation. And just a few data about the relevance of global supply chains in today's world. According to an ITUC survey, more than 60% of global trade is dependent on contract in supply chains, whether national or global. And 50% of the world's largest company employ only the 6% of their workforce directly, while the remaining 94% is hired through their global supply chain. So there is the supply chain basically function as an intermediary between the workers and the subject that gain the profits, the multinational corporation. In the paper I'm presenting, there is a comparative part about laws on supply chains. I'm not going through these slides, however, because of the time, but of course there could be room for discussion. And I'm going to focus directly on pieces of legislation that has an international scope of application. So basically nation-state or in any case binding laws that encompass the whole global supply chain worldwide. And there are two main techniques adopted so far, and one is social reporting. I mentioned the EU directive on the disclosure of non-financial information, but you may also know, for instance, the UK Modern Slavery Act, and in particular the Article 54 about transparency in global supply chains, or the similar California Act from 2011, I think. But the most interesting example is the due diligence, and in particular the duty of care adopted by the French law on, indeed, the duty of care of the mother companies. And this is particularly interesting because this law requires largest French corporation to adopt and to implement a due diligence plan in order to identify the major risks and prevent gross violation of human rights, health and safety issue at work, and environmental issues, not only within their operation and within their subsidiaries, but also in any contracts that in any commercial relation that has a kind of ongoing character. So it's a very strong piece of legislation, but the problem is how can it be ensured an extraterritorial control? As we all know, the nation-state have the monopoly of legitimate use of power within their territory, but how can the state go beyond? One answer broadly adopted in normal corporate social responsibility instrument is audit, whether internal or external. However, literature has largely pointed out its inadequacies and its shortcomings the shortcoming of audit. And I just listed a few of them: inadequate procedures, inspectors that suffer from management biases because they usually are not trained for social inspection, the risk of conflict of interests, and again, deceptive practices like forging reports or even hiding part of business. And the most important issue, in my opinion, is the lack of worker involvement. Workers are passive and not actively involved within these processes. So, how can those shortcomings overcome? In my opinion, the involvement of global union in the process of implementation of such laws can be very profitable, both for workers and for nation states who want, we could say, like in kind of an egoistic way, to prevent some kind of race to the bottom. And from a theoretical point of view, global unions have widespread networks worldwide. They are present in some 140, 150 countries, even tricky countries such as Bangladesh, and they are workers' representative, and because of that, they have a specific expertise in this issue, and of course this should prevent the risk of conflict of interest. And we have many practical cases where global union have somehow successfully implement and carried out practices of control and monitoring of global supply chains. The Bangladesh Accord on Fire and Building Safety from 2013, now renewed for another couple of years or more. But the more interesting instrument of this kind is global framework agreements. I don't have a specific slide on this, but in recent times, the Global Union Federation Industrial has started to negotiate and implement new agreements specifically devised for being applied throughout the whole supply chain, and not just within the multinational corporation and its subsidiaries. And those agreements can now be baked by the pieces of legislation I mentioned above, and in particular by the French law, and can turn out to be a very strong, right now, hard law instrument to this aim. So to conclude, this cooperation between states and national legislation and global unions can be mutually beneficial, because state would regain a bit of sovereignty over their multinational corporations' foreign operation, and union would strengthen their presence also in difficult areas and in countries or in sector where unionization is weak. So this could be a first step. Of course, this is not there is no quick and easy solution, but in my view, this is a first step, and the unique step, the the most efficient step that we can now identify towards in order to gain workers' collective empowerment vis-a-vis global supply multinational corporations and their global supply chains. Thank you for your attention. I skipped a few arguments, so if there's something that I have not explained very well, I hope there will be room for discussion on it, and I would be glad to answer your questions.
Thank you.
Thank you.